All right, now let's call the first case, Menefee versus State of Florida.
Good morning, may it please the court, Your Honor. I'm Gray Thomas of the firm of Shepard, White, Thomas, and Kuchurgis in Jacksonville. I would like to reserve 5 minutes. I'm here representing Jim Menefee, who was convicted of misdemeanor stalking in Citrus County and sentenced to a year in the county jail, despite having no prior criminal record. It's undisputed in this case that the conduct involved...
I'm sorry, is that significant to the legal issues in the case?
No, I just think it's a significant piece of knowledge. It is not determinative of a legal issue in the case. It is undisputed that the conduct involved in this case was solely communication via licensed amateur radio, ham radio, from between 2 licensed operators, licensed by the Federal Communications Commission. Both Mr. Menefee and the person characterized as a victim in this case, Mr. Viglione, were both licensed ham radio operators. This is a case in which the specific argument we're advancing in this appeal, to the extent of my research, has been addressed only one time in the United States, and that's in the People versus Vogler case in the mid-'70s in the state of New York. But Hornbook black letter law has recognized...
What did Vogler say?
Well, Vogler held it was a case in which there was radio communication, an individual charged with what under the New York Penal Code was characterized as aggravated harassment by use of a radio, a CB radio. The argument was advanced that the content of radio communications was the exclusive prerogative of federal law and regulation by the Federal Communications Commission.
The conduct in Vogler specifically addressed obscenity, and that is, again, addressed specifically within the statute.
Well,
so Vogler was, the conduct of Vogler was carved out, and that certainly was preempted by the federal government through the FCC. There's a presumption against preemption, is there not?
Well, there's a legal presumption. It's not an evidentiary type of presumption, but also I think that the state has to some extent mischaracterized Vogler. If you look at the first page of Vogler, the defendant was charged with the misdemeanor of aggravated stalking, a violation of Section 240.30, Subdivision 1 of the New York Penal Law.
I'm looking at the facts of Vogler.
Yes.
And what Vogler actually did, what conduct he was being prosecuted for, and the conduct that Vogler was being prosecuted for was obscenity.
I don't think that makes any difference to the outcome, Your Honor, because...
Obscenity, though, is specifically carved out. And the federal government specifically addresses who will handle obscenity over the airwaves of the pursuant to the FCC regulations.
And the Federal Communications Act also addresses harassment. It does so in frankly, a somewhat confused statute. It's Title 47, United States Code Section 223A1C, which seems to address telephonic communications, but also has a potentially broader reading, but it is specific to threats or harassment. That is, and threats and harassment were specifically charged in this case. Title 47, of course, is the Federal Communications Code. Additionally, and we've cited a case or two in our brief, there's a Holcomb case, which is an FCC administrative case, in which harassing amateur radio communications indeed were pursued by the Federal Communications Commission against a licensee, as an action against his license for harassing conduct. And it was pursued under the ambit of the provision of the Communications Act, and both statutory and by rule in the CFRs regarding interference with communications.
So, well, see, here's what's troubling to me about your argument. Let me be upfront about this. It seems to me that there is a difference between regulating the content of what a ham radio operator, regulating what happens with ham radio operators or what happens with ham radios, and with punishing conduct. In other words, I don't think that the state could adopt a statute that regulated what you could say on a ham radio, because to do so would violate preemption. But it seems to me that just like if you had a banner plane which slandered somebody, that conduct could be punished by the state. It seems to me that if you pick up a telephone, which is certainly regulated by the federal government, and called somebody and made those threats, that conduct could certainly amount to a crime. So I don't understand why, if you get on a ham radio and do exactly the same thing that you would do on a telephone, why that would not be punishable by the state. You see what I'm saying?
I do, and I think that plays in part into the distinctions among some of the other decisions. For instance, there are a couple of cases from the Florida Supreme Court that regard preemption arguments in the face of Medicaid-related prosecutions, and a case, the Guharoff case from this court, as well as 2 cases from the 3rd District regarding DUI, operating an airplane under the influence. Well, the statutory schemes in those contexts specifically contemplate either a joint regulation in the Medicaid context, a joint effort between the state and federal governments, or, for instance, in the aircraft context, the statute on its face specifically provides for local law enforcement has the authority to do A, B, and C. So I think that those are distinctions. Also, I don't think that the manner in which the court expressed the view that you just expressed, Your Honor, recognizes the extent to which the United States Supreme Court, in the 1940 case of Sanders Brothers, in the 1943 case of the NBC case that's also cited in our brief, specifically spoke of the FCC controls the composition of radio traffic, and that the Communications Act, the whole purpose of it was to centralize enforcement and control of the use of radio frequencies. Then you have the Carroll case from the Third Circuit in 1950, which addressed, it was on that case was a facial challenge to a statute purporting to allow state censorship of television broadcasting of certain movies. But in that case, the Carroll court specifically concluded that the Federal Communications Act occupies the field of radio and telecommunications, radio and television communications. And so it precludes any state regulation of the content of those broadcast communications.
Counsel, how do you respond to the argument that the state isn't trying to restrict the language that's used, but rather the results of the language that caused emotional distress?
The federal law is in place to regulate that as well. And the content...
The effect, it's in law, it's in, okay.
To me, this is different than shooting a gun across a county or a state line and the bullet hits somebody on the other end. Because the very nature of radio is incapable of being intrastate. It is, by its very nature, incapable of being confined to state lines. Therefore, that's one of the reasons why the Federal Communications Act was necessary, and before it even the Radio Act, in order to centralize and make nationally uniform the whole scheme of regulating both the issues relating to licenses as well as the issues relating to content. And what you have in this case is, in my view, you've got at least 2 types of preemption. First, you have the implied preemption of the field because of the pervasiveness of the federal regulatory scheme, both through statute and regulation. You also have, though, implied conflict preemption because state action that purports to regulate or penalize a use of radio for communications or otherwise is an obstacle to the achievement of the purposes and objectives of the Federal Communications Act, which is to create nationally uniform regulation of communication of an inherently interstate means of communication. It comes pretty darn close to express preemption, because Section 151 of Title 47 specifically describes that the entire purpose of the Federal Communications Act is to centralize authority. Section 152 of the Act specifically provides that it addresses all radio communication. The FCC does regulate this type of conduct, and the Communications Act was designed to create an organization, the FCC, for that purpose.
Well, can the state regulate lawyer advertising on the television or radio, on the radio?
The state can regulate a certain conduct of a lawyer. That has always been treated very differently as a First Amendment matter by the High Court of Florida.
But the state can do it. The state can do it.
Well, the state Supreme Court regulates lawyers.
Well, yeah, we all understand that.
Yes.
Believe me, we all understand that.
Right. Absolutely. That whole approach is a matter of First Amendment law that is a very unique area, in my view, and I've actually litigated that issue as well. It's a totally different animal than this preemption argument.
I don't want to run you out of time.
Well, the Head versus New Mexico almost dealt with that on point, did it not?
Pretty close, yes. Thank you. I'll reserve the balance.
You have about 3 minutes left. All right, so Mr. Height, where in the world does the state get off charging this as a crime?
May it please the court, I'm Wesley Height, representing the state. The state is exercising its traditional police power. When you look at the case decided by the state, we step in, as the court previously pointed out, and we point out in our brief. This is called the Telephone and Communications Act. We obviously regulate and punish threats on a telephone. Cyber stalking. We come in, we have a specific, in fact, this specific statute now regulates cyber stalking, which involves internets and interstate action. When you look at the FAA and the pilots drinking, the feds regulate that, but so can the state.
Here's what's troubling about this, Mr. Height. 47 CFR section 97.113 says the FCC regulates amateur radio transmissions that include, quote, communications intended to facilitate a criminal act and obscene or indecent words or language. What's troubling to me is that the regulation, the FCC reg, says the regulation includes communications intended to facilitate a criminal act, which of course is what's being charged here. Why isn't that a preemption?
Because you can have arguably concurrent jurisdiction and have concurrent jurisdiction does not preempt the state. There's a presumption the state can exercise its police powers. Additionally, the appellant argues it's undisputed that this was exclusively ham radio. If you look at the testimony, the charging information simply says aggravated stalking, convicted of a stalking. If you look at the facts that were produced by the state, you have telephone calls, you have emails, you have ham radio. So to come and say exclusively this action or that action when it's multiple actions by the defendant.
On ham radio was only part of it.
A large part, yes. But when you look at the testimony, these threats were coming from every media source that existed almost. The defendant and the appellant in this case can be prosecuted federally, but just because he can be prosecuted federally does not mean the state can not step in. When you look at the cases that talk about Medicaid fraud, if you look at pilots flying under the influence. Out of this court, the Harf case, the fact that the federal government can prosecute does not preclude the state. There's no express conflict here. There's no field preemption, and there's no implied conflict preemption. The state traditionally punishes acts, criminal acts. We did so in this case, and we feel that the presumption is in our favor and has not been overcome.
Counsel, does the conduct in this case fall within any federal statute prohibiting it?
I think arguably the Chapter 47 protects against harassment with telephone calls, telecommunication devices to harass the person. If I were a federal prosecutor, I would argue it fits in within that situation. The FCC can come in and regulate. We do not dispute that, but whether the state can come in and also prosecute criminal acts.
Do you see a distinction between regulation and prosecution?
A large distinction. Regulation of the radio waves is the federal, that is preempted, and a regulation is an area where the federal government steps in and has the primary authority. But criminal acts, and again, that's what you see with telephones and the internet currently, and in this case ham radio, if it becomes a criminal act, that's traditionally a matter that the state government will prosecute and did in this case. And if you look at even the appellant really offers that the only case that's even in the field of this area is Vogler. So they're not primarily relying upon the Chapter 47. They're not primarily relying upon the case law dealing with regulation. They're relying upon a New York 1977 town court case which deals with obscenities. And obscenities deal with First Amendment issues. They do not deal with the criminal actions that were in this case. They're not aggravated stalking. The details of the verbal language in Vogler is not there. So factually, I think it's quite distinguishable. If the court for some reason felt it's not, it would be the state's position that it's wrong. The discussion of preemption, I'm not sure the word's even actually used in the Vogler case, but they do talk about conflicts of laws and allow the federal government to take exclusive control in that case. If they feel that there's a preemption in that case, then they're wrong. The state can step in and act. The state did in this case, and unless we're preempted out, we feel it's our exclusive state power, and that's what we exercise in this case.
So you're jumping on the bandwagon and picking on New York?
I am not. I think New York's case is distinguishable.
I think Judge Gone may have a New York background.
I understand. No, far from it.
But I think it's quite distinguishable based upon its facts, but if the court felt otherwise, we would feel that it's wrong. And if there are no further questions, we would ask that you affirm.
Thank you. All right, Mr. Davis, you got 3 minutes.
Thank you. First of all, Vogler does specifically describe evidence of a congressional intent to preempt the sphere of radio broadcasting, and additionally that the statute and rule effectively preempt the state statute. Additionally, the state.
Can I ask you something
Yes,
that's on my mind? The state says that it was more than just the ham radio operation that led to the prosecution. It was telephone calls and other things as well.
That was quite on my mind as well, because the state never mentioned that in argument, contrary to this motion in the court below. The state never mentioned that in its brief.
Is it a fact, though?
There was mention of other interactions that they had, but some of that was more a matter of the historical aspects of it, as I understood it, that there actually had been an altercation when they had been in person together, in which Mr. Viglione physically attacked Mr. Menefee, and that was part of the precursor conduct. That didn't happen during the time period of December 2006 that was charged in the information. But
what did the evidence demonstrate occurred in December of 2006?
In December 2006,
beyond the
evidence demonstrates ham radio.
That's it?
That's my recollection of the record. And if the state is taking a contrary position, they should have done it in their brief or should have done it in the court below, because they never made that argument before today. Additionally, the issue of cyber stalking is a totally different, that's a red herring, because first of all, whether or not, there are dormant commerce clause challenges to internet type of prosecutions that are going. They have not really been successful at this point, but that's totally different. There's not a pervasive statutory federal scheme regarding the internet. One could argue that there ought to be, but there's not. With regard to Section 223 of Title 47, that provision specifically provides that when it comes to telephone harassment, that the states are authorized to take actions in regard to telephone harassment in a manner that would not be inconsistent with the federal law. The state otherwise has accurately stated some general principles and platitudes, none of which are persuasive on the facts of this case, where it's exclusively ham radio. It was stipulated below. It was always stated below, never objected by the state below to the motion to dismiss, that it's exclusively ham radio. That's what we're here for, and this court should reverse.
Thank you, sir.
Thank you.